Hi, my name is Dr. Samara Rashid. Today I will be talking about dentistry and the law, and that would be Chapter 5 in the Modern Dental Assisting Textbook, Edition 13, from the authors Bird and Robinson. Statutory law comes about when the United States Congress, a state legislature, or a local legislative body passes a legislation. And statutory law basically consists of two types, criminal law and civil law. Okay, becoming a dental assistant, you will be more, I guess, in tune in terms of what is allowed legally in the clinic and what is not allowed. So that's why the book exposes you a little bit in terms of what, in terms of what the laws say. So let's talk a little bit about criminal law. So criminal law are crimes against society, deals with any laws that are pertaining to crimes against society. For example, when the government agency initiates legal action and it seeks to punish the offender. Okay? Civil law are crimes against an individual, okay, with another individual initiating legal action. Okay, for example, a lawsuit, and that seeks to compensate the victim. Civil law is very much more with what dentistry would deal with rather than criminal law. So it's more so civil law is what more we deal with. But jurisprudence in general, some providers have to take jurisprudence exams as per whatever state they move to or wherever they graduate from. And jurisprudence basically deals with the science of law. Criminal law. So the crimes against society where the offender is punished and the victim is compensated. Sorry, my spelling is off. And the victim is compensated. Criminal offenses, in terms of classification, the book kind of divides it up into a felony, a misdemeanor, and an infraction. I'm sure some of you have seen some episodes of Law and Order SVU. There's a lot of law, shows on TV lately. And you might, if you watch those, a lot of these terms come up. So when it comes to felony is a major crime. A conviction may result in actually going into imprisonment. Misdemeanor is more of a lesser offense, and it results in a variety of penalties, fines, a loss, or even suspension of your licensure. You may have to do community service. So an example of that is a dentist that violates the DPA by not following infection control. Okay, let's say someone says there's an OSHA violation with this clinic. So that could be a misdemeanor, okay? An infraction is more of a minor offense. It usually only results in a fine. For example, a traffic violation, a speeding ticket. Civil law deals with relations of individuals, corporations, or other organizations. And the classifications of it are contract law, tort law, and administrative law. Contract law is more as what it says. It's a binding agreement between two or more people. Tort law acts that they bring harm to a person or property. So actions that bring harm to a person or property. And then of course there's administrative law. And those are regulations established by government agencies. Contract law is more for a binding contract. It's more, it's more of a promise for a binding contract. So it must be established between two competent people, okay? And that eliminates the mentally incompetent people, those that are under the influence, and of course minors. So it can't just be anyone. It must include an exchange of service for payment. So when a dentist accepts a patient and arrives for care, the dentist has legal obligation under contract law to provide dental care. Of course, contract law can be express contracts or implied contracts. Express contracts are written or verbal, and it's used when treatment will take a long time, like orthodontics, okay? Implied contracts are basically established by actions and not words. So most dental contracts are implied. For example, a patient comes to you with a toothache. Okay, I mean, we're assuming the patient, when they sit down, they're allowing an exam. It's implied that the patient wants treatment. So those are implied contracts. Tort law is basically a civil wrong, okay? It can be intentional or unintentional. And intentional, it's a breach of confidentiality, for example, okay? Their, their information was leaked. It's intentional, it could be intentional. Unintentional is if radiographs, for example, were mounted wrong and the dentist extracted or removed a tooth on the wrong side. Like, it could be that, yes, it was, they could be liable for it, of course. But at the same time, it's a violation of tort law, but it was unintentional. Tort law can be an act of omission. It involves with an act of commission. Now, an act of omission is just basically not doing something that should have been done, okay? You just decided not to take radiographs, for example. So you omitted any type of information that could be provided through x-rays. Commission is doing something that should not have been done. It just should not have been done. For example, causing nerve injury during tooth extraction, okay? It should not have been done, causing nerve injury during tooth extraction. Okay, your book talks a little bit about the State Dental Practice Act, and it protects the public from incompetent dental health care providers. They don't want just anyone, coming in and saying, hey, I'm a dentist, I'm gonna work on you, or I'm a dental assistant, I'm just gonna walk in and I'm just gonna help you. I mean, it's meant to protect the public. It's established by each state. It specifies legal requirements for practice of dentistry within each state. It can be a single law or like a bundle of laws. It varies greatly for dental assistants from state to state. And where we talked a little bit about that, and you could go ahead and take a look at www.ada.org. That'll really tell you the details as to what is allowed or what is permissible with dental assistants from state to state. It governs requirements for licensure, okay, the duties delegated to dental assistants, and infection control regulations. So it's a pretty important act. You'll also see the word over and over mentioned, the term Board of Dentistry. So the Board of Dentistry is an administrative board. It translates or interprets or implements state regulations. Its members usually are appointed by each governor's state dental board, okay? And it adopts rules and regulations that define, interpret, and even implement the intent of the DPA. And the DPA, of course, is the Dental Practice Act. The Board of Dentistry enforces regulations for the practice of dentistry within the state. When it comes to licensure, having a license to practice in a specific state, okay? And there's a method of supervising individuals who practice. The licensure is meant to protect the public from incompetence. The licensure, it varies from state to state in terms of rules, but increasing number of states are requiring either licensing or regulation for dental assistants in their state. They're getting more and more strict. And you saw that when you went back to chapter 1 and 2, when we talked a little bit about previous, like in history, when dentistry just came out, and when there was when we had Southard and we had the dental assistants that were up and coming, more and more people were being employed. There were more women. There was more diversity also, and because there was so much more people involved with dentistry, there was more and more regulations. They learned that, you know what, we got to have some rules here. Reciprocity, you might have heard of. Reciprocity is an agreement between two or more states that allows a dentist or a dental hygienist who is licensed in one state to receive, usually without further examination requirements, a license to practice in any of the other states in the reciprocity agreement. So reciprocity is more like, let's say I have a license to practice dentistry in Virginia, and let's say New Jersey says, yeah, we accept the same licensure from Virginia without any type of exam or anything like that. You can come on into Virginia and just apply for the licensure, and we'll grant you that. So there is reciprocity. Oftentimes, for example, with medical degrees, they have universal reciprocity, meaning they can use their degree in any state of America. When the pandemic first occurred and everybody, went into quarantine, and there was a huge deficiency in medical care in many of the hospitals because they reached capacity, because a lot of patients were being diagnosed with COVID-19, they were being admitted, a lot of people were dying. What happened was it was granted to have universal reciprocity immediately for medical the medical field, for many of those in the medical field, because they were like, we got to lift these restrictions up, because if we don't, we're going to have a lot of deaths, and because there's just not enough staff. So that's just an example, I wanted to pertain to when it came to reciprocity. The licensure by credential. So licensure by credential, it allows an individual who is currently licensed in one state to become licensed in another state if certain requirements are met. Okay, for example, if you have to do like 1,000 hours of something, so it's licensed by credentialing, or you had to take this exam or something, and that way you'll get licensure. The Board of Dentistry has the authority to issue a license, but also has the right to revoke, suspend, or deny the renewal of a license. Okay, expanded functions or duties specific to intraoral tasks, they're delegated to qualified dental auxiliaries. It's more an advanced skill and training. It could be delegated to a dental assistant. Some states do require additional training or certification in order to be an expanded function dental assistant. It's included in the doctrine of the respondent superior. For example, let the master answer. And your book talks a little bit of that term, the respondent superior, let the master answer. The employer is responsible for any harm caused by actions of the employee while the employee is carrying out business of the employer. And it means the patient may sue the dentist for error committed by the dental assistant, okay? And the injured patient may also file a suit against the dental assistant. So in the past, a lot of dental assistants said, oh yeah, I'm working for the dentist. I'm not liable. I don't have anything to worry about. But you know what? You'll remember what I said in the last few lectures, that when, there's a problem or miscommunication, or when, a patient unfortunately wants to seek legal action, there's a tendency for legal action to be against everyone in the clinic or in the office, not just one person. So dentist liability insurance cannot be counted on to provide complete coverage for the dental assistant. You may need to get your own. So many dental assistants choose to carry their own liability insurance, okay? And don't forget the term. The term dental auxiliary applies to a dental assistant or a dental hygienist. Okay, we're continuing on with the expanded functions and supervisions. A patient of record, you'll hear that term often in the clinic. To say, is this a patient of record? So what that basically means is it's an individual who has been examined and diagnosed by a licensed dentist and has his or her treatment planned by the dentist. Direct supervision, a dentist has delegated specific procedures to be performed for a patient of record by a legally qualified dental auxiliary. A dentist must examine a patient before delegating the procedure, and again when the procedure is complete. That's direct. The dentist must be physically present in the office at the time the procedures are performed. Okay, so they have to be literally present there. Of course, there's indirect supervision, or generally known as general supervision. The dentist has authorized and delegated specific procedures that may be performed by a legally qualified dental auxiliary for a patient of record. Okay, so they're delegated to that individual. The unlicensed practice of dentistry, if the dentist asks you to perform an expanded function that is not legal in your state and you choose to do so, you're actually committing a criminal act, okay? So just to summarize, to the right, this comes from your book. It's a list of the expanded functions that are delegated to the qualified dental assistant. This is what you can do as an expanded function. So if you feel that you're not supposed to be doing something, you can be committing a criminal act. Okay, a little bit about the dentist-patient relationship. There is a standard of care that is lived up to, a duty of care. So it's really not a black and white rule. There is a legal concept that provides general boundaries within which a dentist must perform in a given situation. The standard of care that a dentist must meet is simply the customary practice of reputable dentists who have similar training and experience, who practice in similar disciplines, or who practice in the same area or similar locality, like in an urban area, a remote rural area. Okay, so it's not a black and white rule, the standard of care. Okay, so there is some interpretation. The duty of care owed by a dentist to a patient includes being licensed. That goes without saying. Using reasonable skill, care, and judgment. and using standard drugs, materials, and techniques. A dentist may refuse to treat a patient, but they must not be based on the patient's race, color, or creed. Okay, the duty of care, the standard of care. So a dentist's duty of care to the patient includes things like be properly licensed, do not exceed the scope of practice or allow assistance under general supervision to perform unlawful acts, to achieve reasonable treatment results, or arrange for a patient's care during a temporary absence. So these are just a slew of items that involve the duty of care to the patient by the dentist. Abandonment, you might have heard of this from before, but it's a very important term. It refers to discontinuation of care after treatment has begun, but before it has been completed. A patient must receive reasonable notice of ending of a dentist-patient relationship. It happens, there are many times where, let's say a dentist becomes pregnant. She has to leave. She has to take leave of absence. So, there has to be a reasonable notice of ending the dentist-patient relationship if the dentist won't come back. Okay, so things happen in life, but there has to be reasonable notice. Okay, the patient also has legal responsibilities to the dentist. The patient is legally required to pay a reasonable and agreed on fee for services. The patient is also expected to cooperate and follow those instructions regarding treatment and home care. Like, you can't just get, you got a tooth pulled and you didn't follow the post-operative instructions, and you're going to learn that there's post-operative instructions when you get a tooth pulled, and they don't follow it, and all of a sudden they develop something called dry socket. They can't just say, oh, you did this to me, or your staff or your clinic did this to me. They also they're expected to follow instructions that are given to them. And don't forget, the dentist and you will be documenting everything that is being done in the office. You'll be documenting the fact that you gave a written and a verbal post-operative instructions after a specific procedure all the time. Okay, due care, you may have heard of this term, due care. It's a legal term that means proper and sufficient care or the absence of negligence. A dentist has the legal obligation, which applies to all treatment procedures, to provide due care in treating patients. Malpractice, a very, very, very common word. Not necessarily a bad word. You'll hear malpractice insurance and stuff like that. But there's basically the 4 Ds, 4 conditions that must all be present for a malpractice lawsuit to be successful. Anybody can sue anyone, but we have to be reasonable here now. There's 4 conditions or 4 Ds that have to be present. First of all, you have to have duty. A dentist-patient relationship must exist, okay, to even establish the duty. Then you have derelict, lacking a sense of duty or negligence. So negligence occurred because the standard of care was not met. Okay. Then you have to have direct cause. The negligent act was the direct cause of the injury. You have to show that, you didn't go home and come back after a month and said, well, you did a filling, but look what happened. Yeah, but Ms. McGillicuddy or Ms. Smith, whoever, is coming back after a month, and that's kind of negligent. And she's saying she has a problem now where she didn't really call the office. She didn't tell the office that she was having pain for a whole month. So again, you have to have direct cause. And then of course there's damages. Pain and suffering, loss of income, and medical bills are included in damages. A case example would be a dentist injects local anesthesia on the wrong side of the mouth. Now the 4 Ds are not present in this case. The dentist numbed the wrong side of the mouth, but was any harm done? No, there was no harm done at all. Okay, it may not be good practice to do that, because it's a little bit of a inconvenience, but it is not up for to say, oh, this is a malpractice lawsuit. It just doesn't look good. The acts of omission and commission, we talked a little bit about that earlier in this lecture. Malpractice is the professional negligence or failure to provide due care or the lack of due care. There's 2 types of malpractice. There's active commission and omission. The act of omission, failure to perform an act that a reasonable and prudent professional would perform. You just didn't do it, okay? That's what it is. The act of commission, performance of an act that a reasonable and prudent professional would not perform, okay? You're going to hear a little bit about the doctrine of res ipsa loquitur. So res ipsa loquitur is, it deals with the act speaks for itself. The evidence is clear. For example, the wrong tooth was extracted. Period. That's it. The wrong tooth was was removed, and it speaks for itself. The evidence is clear, and it was something that was done wrong. Risk management. This refers to procedures and practices that are used to avoid lawsuits. Okay? Major areas of risk management include excellent communication with patients. You always want to communicate, be open about what's going on. You know, for example, let's say you're doing a huge filling because the patient said, that this area hurts me. You find something, and you always want to communicate and say, okay, Ms. Smith or Ms. McGillicuddy, we're being a hero now. Remember, we're doing this. Remember, this might break. Please be advised. Please know that. And yeah, of course, you document that in the notes in the chart that you've explained this to the patient. You also, it also includes maintaining accurate and complete records, receiving informed consent, they have to sign, and doing everything possible to maintain the highest standards of clinical excellence. You will always want to avoid malpractice lawsuits for obvious reasons. Patients are less likely to initiate a lawsuit when they have a clear understanding of the following. They know what's going to happen: planned treatment, reasonable treatment results. They see the results. Okay, it's not up to perfect. It's not up to par perfectly, but it's good. There is some reasonable, reasonable treatment that they see. Potential treatment complications. Okay, they have to understand the pros and cons of what can happen. Their own financial obligations. They have to know that, there is a financial responsibility on their part, and they must owe such and such amount of money. Silence is golden. The dental assistant must never make critical remarks about dental treatment rendered by an employer or another dentist. Ever, ever, ever. The dental assistant should never discuss other patients and should avoid discussing the dentist's professional liability insurance. Remember, your team, no matter what. You have to not talk about certain sensitive topics, like, oh yeah, the dentist, he or she just recently finished a lawsuit. Oh, and then the patient says, oh, they got sued. I mean, that doesn't look good because you're only promoting more negativity in the office. You're getting involved in it. It's a he said, she said type of thing. Res gestae is the term that deals with things that are done, things done. Statements made spontaneously by anyone at the time of the alleged negligent act are admissible as evidence and may be damaging to a dentist and the dental assistant in a court of law. For example, you always want to avoid terms like whoops or uh-oh. So for example, let's say they're in the middle of taking a tooth out. It slips, nothing happens, but it kind of like just falls on the side of the cheek, or like, oh, oops, oh, uh-oh. You want to avoid those outbursts or biased words like that, because remember, the patient is already afraid. They could be afraid of even coming to the dental office. On top of that, they can't see what's going on in the mouth, and you're causing anxiety in the patient. The guidelines for informed consent is based on information provided by the dentist. The dentist must give the patient enough information about his or her condition and all be available treatment options. There's implied consent and written consent. Implied consent is when the patient agrees to treatment, or at least does not object to treatment. It's not really a reliable form of consent in malpractice suit. A written consent would be better because it involves a document, and there's documentation in the patient's consent. You've written it down, and there's an understanding of the procedure, and it's preferred over implied consent. Exceptions to disclosure. A dentist does not have a duty to disclose and for information about a proposed treatment in the following situations. Excuse the spelling. The patient asks not to be advised. Okay. Now, as a dentist or a dental professional, that's not really good to follow. You don't have that duty to say, oh, I can't disclose that information. I mean, the patient asks not to be advised. The procedure is simple and straightforward, and life-threatening risks are remote. Treatment risk is minor, and treatment rarely results in serious adverse effects. The information would be so upsetting that the patient would be unable to weigh risks and benefits rationally, known as therapeutic exception. So the dentist does not have a duty to disclose information about proposed treatment in these situations. Informed consent for minors. The parent, custodial parent, or legal guardian must give consent for minor children. Siblings cannot give consent for children. You'll see that when you do radiology. Many times in the past, we've had students that came, brought in a patient and said, oh, this is the sister of the patient and I'm about to take x-rays. And then I tell the student, nope, you can't do it. You can't take x-rays. And like, why? The sibling is an adult. Nope, it's a sibling. Has to be a legal guardian or parent, okay? You might hear the term blanket consent, okay? That can be asked in advance. It avoids confusion and delays should the child require emergency care, okay, when a parent or guardian is not present, okay? So it can be asked in advance. It does avoid, confusion and delays. Let's say the child is having a problem and you don't want, let's say you're saying, oh, they're having an emergency and I gotta run and get consent. It's like, but that's eating up time and the child's life is in jeopardy. So, that's what we're dealing with when it comes to blanket consent. Okay, your book has a little bit about the patient should be informed about the following in terms of guidelines for informed consent. Documenting informed consent. Okay, any changes in anything they've been taking. For example, new drugs are used. Treatment takes longer than 1 year to complete. Minors are treated in a public program, etc. Okay, the content of informed consent. Consent is a process, so it's not just a piece of paper. A lot of times we just see it as a piece of paper or a form, but it's a process. There's a face-to-face involvement, and there's enough time that should be allotted, such that there's a time for Q&As, question and answers between the provider and the patient. And it should contain the following. Informed consent should have the nature of the proposed treatment, benefits and treatment alternatives, the risks and potential consequences associated with not performing the treatment, and other information as necessary for a particular case. It's signed by the patient, the dentist, and witness. The patient receives a copy, and the original should be kept in the patient's chart. A patient referral, it occurs in an unusual case or a condition beyond their scope of expertise. Many malpractice claims due to failure of the general dentist to refer the patient to a specialist when the patient's oral condition requires special attention. And it has happened. For example, periodontal disease. If you feel that you're doing a deep cleaning and the patient's bone loss is getting worse and worse, in those cases, the patient should be referred because it's out of the scope of the expertise of the practice. There's no real results. So there is an obligation that the patient has to be referred. You can get sued. You can have a malpractice lawsuit on the doctor or the actual practice because it wasn't referred in the proper time. So when a person is referred to a specialist, the referral should be thoroughly documented in the patient's chart. A lot of times you're going to see the patient says, oh, please don't say I have to go to that specialist because the prices are high, but you have to do it. I mean, they can refuse to go, but it's got to be documented that they refuse to go. And it's got to be documented that that's what you recommended. Guarantees. Dental care cannot be completely predicted. Okay, so it's unethical to make guarantees. Okay, in fact, in some states, it's actually illegal. Contributory negligence. Okay, when a patient's action or lack of action negatively affects the treatment outcome. Okay, broken and canceled appointments must be documented. Okay, and this documentation is not to, a lot of people say, oh, it looks bad on the patient, but it's not for that. It's to protect the practice from legal recourse should a patient claim negligence against the dentist. And the patient turns around and says, well, you know what, you did this or you did that. So, it's to protect the actual practice. When it comes to contributory negligence, when a patient's action or lack of action negatively affects the treatment outcome, you're basically dealing with contributory negligence. Broken and canceled appointments must be documented. And again, just like what I said a few seconds ago, I think there was a problem with the recording, but the documentation of these canceled or broken appointments protects the practice from legal recourse if a patient were to claim negligence against the dentist or the office in the future. So document, document, document. I cannot stress that enough. Patient records. A patient record is basically a dental chart, okay? It's considered records regarding patient care. They are important legal documents. They have to be protected They have to be handled with care. Nothing should be left to just memory, like, oh, I remember Miss Smith, or I remember Miss McGillicuddy saying this when she was getting the crown. No, if it's not written, guess what? It never happened. So that's a big challenge. It's acceptable in court and clearly shows dates and details of services rendered. If the patient records are incomplete or uncleared, then it's considered damaging evidence in malpractice cases. Every entry in the chart for every day or every encounter should be made as if the chart will be seen in a court of law. Ownership of dental records and radiographs. The dentist technically owns all the patient records and radiographs. And in some states, the patients have the right to access and retrieve their records and radiographs. Original records and radiographs cannot be taken from the practice without the dentist's permission. In fact, I cannot stress it so much that in many practices, patients have to sign a release form saying that, yes, I give permission, or I would like my records, and then the dentist keeps the original, and maybe perhaps they can get a copy. But the dentist has the right to keep the original. Ownership of the dental records and radiographs. Again, here you have some guidelines that's taken directly from your book on page 37. And it gives you some important bullet points, like, for example, keep a separate chart for each patient. Don't use a group chart for an entire family. Business and financial information is not part of the clinical record. You'll notice that when it comes to finances, they're in a separate, it could be in a separate binder or even a separate chart, but it's not part of the actual clinical record. It's better to chart too much information than too little. Okay? So go ahead and review these on your own. You're going to see a lot of this stuff be repeated, for example, in chapter 26. When you're reporting abuse and neglect, and this is a very important topic, abuse can occur inside or outside of the home. There are many injuries that occur around the mouth, the neck, face, and head. And this is recognized by you, the dental health team, and you're going to be the one that's going to be seeing this up and close. So when it comes to any type of neglect or abuse, it's very important that it be taken seriously. For example, dental professionals, the whole dental team, we're considered mandated reporters. Dental professionals must report suspected abuse if they observe signs of abuse or if they have reasonable suspicion of abuse. Now, I'm not saying go out and start saying this one is abused, that one's abused. I mean, it's a serious allegation. You have to make sure that you are sure of the findings that you have found with the patient. Report may be made to a social work agency, a county welfare or probation department, or a police or sheriff's department. The basic types of abuse are child abuse, spousal abuse, elder abuse, and dental neglect. Child abuse. When it comes to child abuse, a child, when we say child, we're saying 18 years of age or older is not a child, okay? A child has to be 18 years of age or younger. So approximately 75% of child abuse injuries involve head, neck, or mouth area. And the primary intent of reporting abuse is to protect the child. We're not doing this because, we want ill intent, we want them to be separated from the adult. We want to protect the child. It's legally defined as any act of omission or commission that endangers or impairs a child's physical or emotional health and development. This includes the physical abuse and corporal punishment resulting in injury, emotional abuse, emotional deprivation, physical neglect or inadequate supervision, sexual abuse or exploitation. Warning signs include repeated injury or multiple bruises, unusual sites of accidental injury such as the neck or cheeks, neglected appearance of the patient, strict and overly critical patients, extremely isolated families. Again, document. Whatever you find, you should write it. Domestic violence is another abuse. It's a term used to describe battering abuse or control over an intimate individual within the same household. A victim may deny an abuse incident or may say that the report was filed without permission. Spousal abuse should be reported with consent of the abused spouse. Document. Elder abuse, it's often, not taken really seriously. An elder is considered 65 years of age or older. When a relative or a healthcare provider abuses an elderly patient, that is considered elder abuse. Look for signs of physical abuse and for behavior that suggests abuse, such as being withdrawn. You know, they just don't seem interested. One of the problems with identifying it is that elderly people may not wish to report the actions of a son or a daughter because that offspring is taking care of them, or there's some sort of financial obligation that they're relying on them for. Some fear of the thought of the consequences are reporting abuse and worry about who will take care of them, okay? Dental neglect. We often think, you know, everybody's teeth, you know, it's secondary, but believe it or not, it could be considered abuse. Willful failure of a person or guardian to seek and obtain appropriate treatment for caries and oral infection. Okay, willful failure. They're doing it on purpose. It consists of the following: untreated or rampant caries, and that's easily detected by a layperson. Chronic pain, delay or retardation in a group child growth or development, child's difficulty with or inability to perform daily activities like playing or going to school. So it can be very detrimental on a child. Indicators of child abuse and neglect. You know, your book talks a little bit about it with a few bullet points that it has. But overall, you know, this is what it says: a child is wary of adult contacts. The child is apprehensive when other children cry. The child is afraid to go home and frightened of the parents. And these are things that you should, you know, really look into. And you can see a little bit of this on page 38 in your textbook. Okay. And again, this is a continuation of the bullet points that are in your textbook as well. Immunity is granted from criminal and civil liability for reporting as required. So don't be afraid that, oh boy, I'm gonna have to, you know, I'm gonna get involved. I don't want to say anything. No, you don't be afraid, because you have immunity. Dental professionals cannot be sued for reporting suspicions in an attempt to protect a potential victim. You cannot be sued, because if that existed, trust me, nobody would be reporting such suspicious acts. HIPAA, we talked a little bit about this in chapter 1 and 2. The Privacy Act, so this is enacted by Congress in 1996. The Health Insurance Portability and Accountability Act, again, sorry for the, you know, the lack of capitalization. It's to provide consumers with greater access to healthcare insurance, to protect the privacy of protected health information, and also to promote greater standardization and to enhance efficiency in healthcare industry. Okay, your book has a few bullet points again on page 38, you know, about in terms of the purpose of HIPAA. And it's really important to enforce HIPAA because it reduces fraud and abuse. And it's to provide tax credits for employers, to encourage employee medical savings accounts, to encourage administrative simplification in healthcare while maintaining patient confidentiality. Thank you so much.